Welcome, LA Progressive friends and family. Dick and I are once again joined by Bill Blum. We're also fortunate to have you, Bill. You're going to be talking about a piece that you've written in the LA Progressive that discusses the ending of birthright citizenship. But let me just give you a little bit of background on Bill Blum. He's a former judge and death penalty defense attorney, and he's the author of 3 legal thrillers published by Penguin Putnam: Prejudicial Era, The Last Appeal, and The Face of Justice. Welcome, Bill.
Thanks. Always great to be with you.
So talk to us, this birthright citizenship. You know, we had a Supreme Court case, then we had some other stuff that happened actually today. What the heck is Trump doing, and why did the Supreme Court decision, did it address birthright citizenship or did it not?
So this is all pretty complicated. On January 20th, Trump issued an executive order which radically altered the interpretation of the citizenship clause of the 14th Amendment. That's the very first sentence of the 14th Amendment. And that basically says all persons born in or naturalized in the United States and subject to the jurisdiction thereof are citizens. And Trump's executive order said that that clause essentially was intended only to apply to former Black slaves and the children of Black slaves. And it wasn't supposed to be universal. And that contradicts not only the clear language of this citizenship clause, but Supreme Court precedent decisions dating back to 1898. So what happened after Trump issued this executive order is that various litigants went to federal district court seeking to overturn the executive order, seeking to enjoin it. And the Supreme Court, those district court judges enjoined the enforcement of the executive order, and the Supreme Court eventually took appeals, emergency appeals, filed by the Trump administration, but not on the core issue of whether the executive order conflicted with the citizenship clause, but with whether or not the district court judges had the authority to issue what's called nationwide or universal injunctions prohibiting the administration from enforcing the executive order throughout the entire country, rather than as to only plaintiffs in each case. And it gets real complicated because it's a procedural decision, which purportedly didn't touch the core issue, but then gets deep into the weeds about the history of universal injunctions and asserts that federal lower court judges don't have any power, generally speaking. There are some caveats, which makes it very, very complicated to issue these sorts of injunctions. And the decision of the Supreme Court was a 6-3 decision, split along ideological lines. The majority decision written by Amy Coney Barrett. This case originated in the Supreme Court as an emergency appeal, which we also call a shadow docket appeal. It wasn't supposed to be a merits decision, and it still isn't a merits decision, but unlike other shadow docket cases, this one was given oral argument. So it kind of was it's sort of a hybrid between the regular standard merits docket of the Supreme Court, which is steadily shrinking, and these emergency appeals or shadow docket cases that are steadily expanding. Now, the majority went out of its way to say, we're not ruling on whether or not the executive order conflicts with the 14th Amendment, and we're not making a ruling on the merits of birthright citizenship, just that these judges overstepped their authority. And then Amy Coney Barrett says, well, there are still various ways that these cases could proceed. One is as class actions, Another would be as challenges under the Administrative Procedures Act, which is another federal statute. And the third, in cases brought by state governments, they could proceed with the states as plaintiffs, and the states have joined, 22 states have joined this kind of litigation on behalf of their residents. And she even throws out the possibility that states might be able to get universal injunctions, because in order for any particular state to get complete relief in its particular case, it might have to get a nationwide injunction. And she gives an example that, let's say, she doesn't refer to the state, but let's say California is one of the states, and it is, that would enjoin this executive order. So California would not just recognize birthright citizenship for its residents, but what about a child who comes from, say, Texas, which wouldn't be a citizen at birth but moves to California? How would California keep track of the children who wouldn't be citizens and distinguish them from the children who would? It becomes an administrative nightmare. So she throws open that possibility. Now, today, in a case in New Hampshire brought by the ACLU, which was not one of the cases that the Supreme Court consolidated for its birthright ruling, issued a universal injunction based on nationwide class standing for all children born after the effective date of the injunction of the executive order and their parents.
Okay, so
and that's where we are today.
So yeah, before you go any further, you stated that this whole thing is very complex, and it is. However, yes, I want to, for our audience who really want to have a deeper understanding of this, I want to take the language that you used and break it down for people who have not been to law school, or people who really need to understand what happened. So you started off with January with President Trump issuing this executive order, and his executive order, most people feel, is unconstitutional because it violates what we had already had in the 14th Amendment of the Constitution, that basically states that if you're born in the United States, regardless of the status of your parents, doesn't matter if they're documented, undocumented, if you're born in the United States or you're naturalized, you are a citizen of the United States, regardless of which state it is. He says that 14th Amendment did not apply to everyone, that it was written specifically for people who were enslaved, the Black people, African Americans, who were enslaved at that time that the 14th Amendment was written. But anyway, he did issue this executive order, which, if that executive order had been allowed to stay, people from January to now who were born to people who were undocumented or people that had temporary status wouldn't be citizens of the United States.
Well, for February 19 on.
Oh, February 19.
Gave 30 days from the executive order.
Right. So to stop that from being effective, an injunction was issued, which stops the president's executive order. We maintain the status quo, and the status quo is that people born in the United States are citizens of the United States. So we maintain that, even though he had an executive order, his executive order was stopped because of an injunction. But that injunction, which occurred by a state court, applied to the entire United States, all 50 states. And what was decided on June 27th, a month or so ago, or less than a month ago, what was decided by the United States Supreme Court was not the constitutionality of birthright citizenship. What was decided was whether or not a state court could issue an injunction that would be effective on all 50 states.
Right. Well, a lower federal court, not a state court. Whether a district court,
a lower federal court in a state, a district court with, well, like the ninth district is several states. It's could make a determination that would impact all of the other rest of the nation. And the Supreme Court said a state cannot do that, but Amy Coney Barrett did provide a window of opportunity, an opening. And it wasn't really that opening that the ACLU took advantage of. The ACLU today, the decision that was made as a result of the ACLU's class action. You want to talk about the decision that came down today, right?
Well,
today.
The judge there certified a nationwide class. So that's in keeping with Barrett's decision. And I'm calling it a decision because it's still an emergency appeal. I'm using the term decision on purpose rather than opinion, even though they're interchangeable basically. And that's because it still is an emergency appeal. And the way you can tell is if you look at the Supreme Court's case numbers, the emergency appeals have an A, a capital A in the middle of the case number. The standard docket cases don't. Yeah, so that's one way you can tell. Now, what the Supreme Court should have done is they should have denied the emergency appeals, the emergency appeal filed by the Trump administration. And that would have left all the nationwide injunctions in place. And all of those cases did address the core issue, because when you're dealing with an injunction, a preliminary injunction, you're saying as the judge that the prevailing party is likely to prevail when the case is final. So you're basically making up the decision. I mean, there are some cases where you might get a preliminary injunction and then fail to get the final injunction, but that's rare. So what the Supreme Court should have done, and this is what Sotomayor points out in her dissent, is that this is the rare case where if ever a universal injunction is warranted, it's this sort of case because the executive order, the action that's being challenged, is so blatantly unconstitutional. And that's really where the Supreme Court should have gone, and it could have stopped all this other litigation, which is going to percolate now for another couple of years. And in the meantime, at least in 28 states, and we don't know how it'll affect the 22 states that have challenged because of what's called standing, which is another complication. Children who are born to undocumented immigrants and those with temporary status are basically going to be stateless unless the countries of their parents would recognize their citizenship deriving from their parents. And I don't know whether all of them would or all of them do, probably not. So, especially some of the political asylees. So it really created this complicated mess that the lower courts have to figure out, and it's going to take a long time to do that. Eventually, this will come back to the Supreme Court. And I don't think that even this court will sustain Trump's executive order. I think it will hold that it's unconstitutional. The only conceivable basis, and this is consistent with the language of the Citizenship Clause, it has that phrase, subject to the jurisdiction thereof. Basically, all that means is that when you're on American soil, you're subject to American law. But there are these exceptions for invading armies. If you had an occupying army in the United States and somehow the occupying soldiers had a baby, then that baby wouldn't be subject to U.S. jurisdiction. Also, the children of diplomats, that's long been excluded. And initially, Native American children were excluded, but that was cured with the Native American Citizenship Act in 1924. So the net effect of all this is a terrible mess, which hands Trump this at least temporary victory, a big victory, really, because now that universal injunctions are all but eliminated, you think about all the other executive orders that he has issued, and some of them are going to be subject to this ruling. One of them in particular is on voting procedures. And Mark Elias, who's one of these key election attorneys, got a universal injunction against many of the provisions in that voting executive order, that voting rights order. The last thing I read was that the Department of Justice said you have to modify your universal injunction in that case to limit it to the 19 states that joined that particular lawsuit. So in the other 31, the executive order would remain in effect, would not be affected by the injunction that's been issued for the voting rights. So this has ramifications across the board. And it just shows again that this Supreme Court is really in the pocket of Donald Trump. And it's unfortunate for everybody.
Yeah, so I had two thoughts. One thought, in following what you just said in the article itself, you call it a complicated mess. And it seemed like it's a complicated mess just on that last point you made, because they started with the conclusion they wanted to reach, and then they jury-rigged the excuses in the laws and stretching the laws to come out with that. And then the second point was at the end of your article, you note that Justice Ketanji Brown Jackson issued a separate dissent and called this an existential threat to the rule of law. How so?
Well, because if the Supreme Court isn't going to step in and hold the administration accountable, then where's the rule of law? Then the administration's above the law. And that's what she meant.
Wow. Well, so Bill, none of us can get inside the minds of those six Supreme Court justices. But if you had to guess, you say that Trump owns them. Why would they do this? Do they have no respect for the rule of law?
No, I don't know that he owns them. I said they're in the pocket. I meant that, that they're really MAGA people, in my view. They basically agree with his ideological agenda. They hold him accountable to a certain extent, but only to a very minor extent. I think that they're all very, very conservative. They're all very reactionary in the true sense of the term, that they want to turn back the clock on human rights and civil liberties. And they use this tool of originalism, where they want to understand the Constitution and statutes according to what they think was the original public meaning at the time that they were adopted. And that leads them into this bizarre search historically for analogs to the current practices. So in Amy Coney Barrett's decision, she takes the reader all the way back to the High Court of Chancery in England, and she asks whether that court in 1789, when the Judiciary Act in the United States was ratified, whether that court was issuing universal injunctions. And she says, no, it wasn't. So therefore, our founding fathers didn't contemplate anything like a universal injunction, and we are therefore not going to allow universal injunctions for the lower courts, except with these minor pathways, which we won't call universal injunctions. We'll call them something else.
So early on in this discussion, you corrected me. I said state courts and you said district courts, which was, of course, the accurate description of the lower court. The decision that came from the lower court came from a district court. To help our listeners, can you explain the difference?
So there's a hierarchy of courts,
yes,
federally, just like there is in every state. And you have at the ground level, the district courts, which have trial courts. They try cases. They have judges who preside over trials. And then above them is a court of appeals. They're called circuit courts. We have 11 geographic ones. And then you have the Supreme Court above that. So these cases originate at the district court level.
Thank you so much, Bill. It's been painful. These series of conversations that we've been having with you over the last couple of years, you have consistently brought to our attention these really important cases. And each time, you warn us, this is not good.
Yeah, it's not good. But the fight goes on, and we have to be aware of what's happening.
Yeah, yes, you're right about that. Well, thank you for helping us understand.
Sure. Anytime. Always great to be with you.
Yeah,
Thank you,
thank you,
Bill.
Bill. Thank you so much.
Have a good one.
Take care.
All righty.
See you at the
Bye-bye.
next train wreck.
Exactly.
Thank you for sticking around. If you like the LA Progressive content and the discussions we have here, please consider clicking the subscribe button below and also give us a thumbs up. That helps to grow our audience by feeding the algorithm, which helps to get this content in front of more eyes. Thanks for stopping by. We really appreciate your support.